very much. I declare this meeting of the Wingecarribee Local Planning Panel of 25th of September 2024 opened at 2:07 p.m. We're slightly late because of technical difficulties in transmitting this meeting live. My apologies for that. My name is Stephen Lehman and I will be the chair of today's meeting. Also sitting on the panel are expert members Sheridan Burke, to my left, Stephen Leithley, who joins us online due to illness from a remote location, and our community member is Chris McCann. Wingecarribee Shire Council acknowledges the Gundungurra and Tharawal people as the traditional custodians of this land we now call the Wingecarribee Shire. The council pays its respects to elders past, present and emerging. Council would also like to extend that respect to all Aboriginal and Torres Strait Islanders present here today. We have one speaker for the meeting. Could I ask, just as a matter of usual procedure, to ensure that your mobile phone is turned to silent, please? There are no apologies for this meeting and there are no declarations of interest in respect of this meeting. All panel members have read the business paper, received a briefing from council staff and familiarised themselves with the properties the subject of the reports today, either by physical site inspections or other appropriate means, including visual aids such as near maps. The panel is charged with considering a planning proposal to insert additional farm stay accommodation provisions into Wingecarribee Local Environmental Plan 2010, item 5.1. A development application for a dwelling house and attached secondary dwelling at number 33 Cordeaux Street, Willow Vale, item 6.1. And delegations and guidelines for the Wingecarribee Local Planning Panel, item 6.2. Council will also sit in confidential session in relation to development applications greater than 180 days to be reported to this panel, item 6.3, and Land and Environment Court matters briefing, item 6.4. So there is one registered speaker today. The time limit, the usual practice for the time limit is 3 minutes. The panel members may have questions for the speaker once you've finished your presentation. Please note that once you've made your presentation and answered any questions, the panel, you will not be given a further opportunity to speak unless asked. I would ask that any and all speakers be heard in silence and that courtesy and respect be observed throughout the meeting. Following the conclusion of the public meeting, the panel will move into closed session to deliberate and will announce its advice in public, which will be webcast, and the minutes and details will be posted on the website by close of business Friday. I have one speaker, that's Mr. Barry Anstey. Would you please address the panel, Mr. Anstey?
Thank you, Mr. Chairman. Is that? Yeah, I think that.
Good, thank you, yes.
Thank you for allowing me to speak. The first item I wish to speak on to is 5.1, the planning proposal. I note that it was originally not supported by the panel and then it's gone to a planning proposal. My concern is that the RU4 zone relates to small lots. My family owns one lot that's RU4, but adjoining it is, it's at 170 Almanamar Road. Adjoining that at 172 is a property that has 15 bedrooms and on its website it says it caters for 55 people. Behind it is another property called Dixieland, which has 8 bedrooms and has now got an approval for 6 ecotourist accommodation. My concern is that the reality is that I support the idea that there be farm stay accommodation, but in relation to these small lots, what we're seeing them turn into is basically accommodation facilities. And that's what we've got adjoining us. And I realise they have to be in conjunction with a use that's related to agriculture, but people are doing bees and distilleries and all sorts of things that they're allowable within the zone. So I think we're opening a door that we shouldn't be opening. And I'd ask you to consider that, either rejecting the idea of being included or alternatively at least applying a minimum site area, which is what the standard SEP does in relation to farm stay accommodation. I think the step is 35 hectares. I think that's probably a bit high, but I think we should be looking at something that's at least 10 hectares to allow farm stay on. That's all I'd like to say in relation to that item. My other item is in relation to...
Before you go on, Mr Anstey, I'll just ask the panel if they have any questions of you on that particular item. Panel, do you have any questions or comments?
No. Well, yes. How did you arrive at? You said initially 35 hectares. Why do you put the size of the allotment a minimum of 10 hectares?
Well, 35, I think, is a measurement that's in the complying development set for farm stay accommodation. 10 hectares is 25 acres. That's probably reasonable that you could get something in farm stay accommodation and still have a commercial entity on that. I think I always thought that the 35, I think it's 35, it might be 30, but I think that's limited a lot of farm stay accommodation. 25 acres, I think, is fairly common. There were subdivisions or minimum lot sizes of 10 hectares, and I think that's probably right. But we've got RU2 zones, or RU4 zones rather, that go down to 2 hectares. I just don't think it's appropriate where the lot size is 2 hectares.
Any other questions or comments? Mr Leithley, remotely?
Yeah. Are you aware of the inclusion of clause 5.24 into the LEP as part of this?
Yeah, I noticed that it's happened, yeah.
Okay, so have you looked at that clause though? Does that, because it basically says you can't do farm stay accommodation, I think, unless it's the same size, the minimum lot size for a dwelling.
That may be so.
I could see clarification on that if Susan Stannard would care to respond. Would you please speak to this point, please?
I would need to go and check the provisions of the LEP clause themselves. I haven't brought that with me.
Right.
But it is the intention that the clause provide excellent guidelines on the assessment of farm stay accommodation in any zone, not just the RU4 zone. The other aspect of it is that it does need to be a commercial farm, and there won't be a lot of RU4 zoned land where a commercial farm is active, and the farm stay needs to be ancillary to that commercial farm use. So it was considered that providing the opportunity in the RU4 zone did enable any farms that were there to take advantage of some form of farm stay, and it is quite a broad range of activities that can occur, including glamping, just a few tents. It's not necessarily a building. I take Mr Anstey's point about the proliferation of short-term holiday rental accommodation throughout the Shire, and yes, that can be a problem for neighbours, but this is nothing like that and not related to that in any way. I am confident that the provisions that are in place would be satisfactory to allow this to proceed, especially the requirement that it remain ancillary to a commercial farm.
Yeah, if I can just add to that, like I've got the joy of having it here in front of me, and it's a jurisdictional prerequisite which is going into the LEP. Development consent, it says, must not be granted to a development for the purpose of farm stay accommodation on a land holding unless the consent authority is satisfied that there is a lawfully erected building on the block, and two, that the lot size is not less than the minimum lot size for a dwelling house on the lot. It's also got to be located, as you've said, on a commercial farm, and a commercial farm is defined means a farm on which agriculture is undertaken, that is, on land categorised as farmland under the Local Government Act, Section 515, or a primary production business within the meaning of the Income Tax Assessment Act 1997 of the Commonwealth. So there are specific provisions there in relation to this form of housing, and the purpose for it, Mr. Anstey, is to assist primary producers. And now I take your point that there are other forms of tourist accommodation that can also be undertaken, whether it's eco-tourist facilities or just straight up tourist and visitor accommodation on some rural land where it's permitted. But this is for specific form of for agri-tourism to support farm-based activities. So I'm just wondering whether you're aware of that difference in it and those requirements.
I'm aware of those requirements, but the situation, as I said when I presented, was that you can get people doing bee farming and you can get people doing distilleries, both of which fit in the concept of what you say of a commercial farm.
Distillery is not a commercial farm.
Well, it's a with respect, it's an
It's a rural industry. It's a rural industry, not a farm activity.
It's an agricultural produce industry, which is allowable in the zone.
But it's not a farm.
I don't think there's a definition of farm within the LEP, but anyway. Look,
Well, the commercial farm definition, I just read you the commercial farm definition, and it doesn't include an agricultural produce industry. That's an industry, type of industry.
Yeah, okay. I take your point. I just still maintain that 2 hectares, what's the point of making this applicable to 2 hectares when basically what you're saying is it's not going to occur on lots of the 2 hectares. So why not restrict it that it can't occur on lots of the 2 hectares? You're basically saying that a farm can't occur on 2 hectares of land. If that's the case, then why create a clause that allows it on 2 hectares of land? I'm saying make it it's allowable on 10 hectares of land.
Okay, well,
Is there minimum lot sizes in the RU4 zone that are 2 hectares, are there?
Yes,
we're not,
most of them are.
look, we're not here to have a debate. We've heard what you said with both of you. I think we move on, okay? We'll deliberate on that. Thank you. Now, the next thing
Is 6.3. 6.3. My concern is that in 6.3, it talks about a resolution of council on the 7th of August. There was in fact 2 resolutions on the 7th of August. I've got copies if you'd like me to hand them up. But the resolution that's not referred to in what's presented to you today that was made on the 7th in relation to development assessment performance was a routine reporting mechanism being developed for development applications which have been lodged for a period of 180 days or more, with short commentary to the monthly meeting of the Wingecarribee Local Planning Panel until the ministerial order dated the 1st of July 2024 is satisfied, such reporting to commence at the September meeting. Now, that's not taken place. That's a direction, that's a minute of council that's not been acted upon. Now, the situation of why it was to come forward is we currently sit with a situation of, for July, the average on the planning league was 321 days for an application average to be determined. Taking it off the portal, the average was 34 days. That's the average. I mean, I've got applications in this council that have been in there for 2.5 months and they're still not taken out of the portal. We need to get a situation that somewhere, in an operational sense, and this is what was the purpose of this minute, that this is reported to you so you can decide what you do, because the next action is to seek a planning administrator from the minister, because, clearly this is all being hidden. Why is this not being reported to this meeting? That's as simple as that. It's just not allowable under codes of conduct or any way. Now, I think I've come along today to flag it to you people because I thought you may not be aware that this resolution was made, but this resolution has been made and you need, now being made aware of it, you need to comment upon it because we've got a situation where people are suffering financially huge amounts of money with the periods of time of development applications, that this needs to be resolved. And it's not resolved by hiding it under the carpet. Would you like me to hand up the minutes that were adopted?
I've asked for a copy of the resolution. I'll be getting that.
There was a resolution to clause 10.21 of Development Assessment Performance on the 7th of August.
Are there any comments or questions? You got them? I should clarify, Mr Anstey, that the panel's only concerned with applications which would have come to it, not
Understand
all
that.
applications.
Yeah, understand that
So
exactly.
to compare it to all applications is not appropriate. It's potentially misleading
Well,
because it's not, all applications are not our concern.
I understand that, but Mr May, when he made this minute and adopted it, was looking to a situation that he was ceasing to be administrator. We're going to an election and he wanted a situation where it would be overseen by somebody and he created this resolution, which I agree, it's not all applications come to you, but he made it so that there would be feedback in relation to it.
So I've got a motion here that talks about the timeframe expectations for development assessments being reported to the council as part of the operational plan 24-25. That's not a matter for this panel.
I don't know where you're reading from. I've got a copy of the minute, which I'm happy to turn up, which is the minute of the 7th of August.
Could somebody bring that to the panel, please?
I'll give you, there's 4 of them, so that...
Okay. The third resolution, okay. Okay. Okay, what I've got here is a routine reporting mechanism be developed for development applications which have been lodged for a period of 180 days or more with short commentary to the monthly meeting of the Wingecarribee Local Planning Panel until the ministerial order dated 1 July 2024 is satisfied. Such reporting to commence at the September meeting. That's what you're referring to.
Yeah.
So that order, as I understand it, is applying to the council, the new council, post administration period.
No, it's to the meeting of this panel.
Yes, yes. Until the ministerial order dated 1 July 2024 is satisfied. Yeah. Such reporting to commence at the September meeting. So, first of all, I'm not familiar with the details of the ministerial order dated 1 July 2024, but I understand it's to do with overseeing the new council for its initial period.
No, that's you're talking about the performance order that the Minister issued on the 20th of September. The Minister on the 1st of July issued to all councils a ministerial order. It was by the Minister of Planning in relation to the processing of development applications.
Okay. So that reporting has been commenced at this meeting. So
Well, there's no list in this meeting of all the development applications that are over 180 days. There's only a list of the development applications that are over 180 days that would normal process come to the panel.
Yes.
But the resolution is that all applications that come to you, and it's prefaced by the fact it relates to the 1st of July ministerial meeting. The ministerial order related to all applications, not just the things that went to the
Well,
planning panel.
that's really going outside the powers of and duties of the panel, isn't it?
I understand that may be so in terms of what you can determine as a DA, but I don't think it goes outside what the ministerial order has brought to the table.
Do you have a copy of the ministerial?
No, not with me.
Okay, so look, I don't think we can resolve this
No,
on the
okay.
hop. I think all I can do is take the question on or the comment on notice, if you
Appreciate
will,
that.
and just see what the appropriate response is. So I'm certainly interested in why we might have DAs that have been in for an extended period of time. In my understanding of the duties of the panel, it relates only to DAs that would have come before the panel, not to all DAs. So that needs to be reconciled, I think, in terms of
there
this
is-
resolution and what the duties are based on the ministerial guidelines.
Yeah, I agree with you.
Okay.
Agree with you 100%.
So thanks for bringing that up. I appreciate
you.
that. Are there any other questions, panel, or comments?
No.
Any, Mr. Leafley, remotely, any questions or comments? No?
Nothing from me. No, I sort of support what you're saying.
Thank you. Thank you very much, Mr. Anstey. It's always a pleasure to hear from you. Becoming regular. And I haven't been here all that long. So anyway, I mean that with the greatest respect. So thank you very much. Thanks. So thank you to he who attended today. I normally say to those who attended, but it's you, sir. As previously advised, the panel will now move into closed session to deliberate and will return to announce its decisions at the conclusion of that deliberation. Those announcements will be live streamed. Thank you. The Wingecarribee Local Planning Panel has deliberated on the items before it at this meeting of the 25th of September 2024. In respect of item 5.1, planning proposal to insert additional farmstay accommodation provisions into Wingecarribee Local Environmental Plan 2010 post-exhibition report, that the local planning panel support the proposal to amend Wingecarribee Local Environmental Plan 2010 to insert clause 5.24 farmstay accommodation and to permit farmstay accommodation with consent in the RU4 primary production zone to be finalised under section 3.36 of the Environmental Planning and Assessment Act 1979. Reason being that the panel notes and agrees with the officer's recommendations, and the voting is unanimous. Item 6.1, a dwelling house and attached secondary dwelling, Lot 8 DP 1286738, number 33 Cordo Street, Willow Vale. The Wingecarribee Local Planning Panel determines the development, I beg your pardon. This is incorrect. I'll start again. The Wingecarribee Local Planning Panel indicates its intent to approve development application DA 24/0189 for development of a dwelling house and secondary dwelling on land at 33 Cordo Street, Willow Vale, by approval, subject to conditions specified in the officer's report, subject to confirmation through written legal advice as to the consent authority's ability to vary the control, it being a development standard, and that the written legal advice be circulated amongst the panel for concurrence prior to approval of the application. The reasons are that the panel notes and agrees with the officer's recommendations, and the voting is unanimous. Item 6.2, delegations and guidelines, Wingecarribee Local Planning Panel. Panel's advice is that the Wingecarribee Local Planning Panel, pursuant to section 2.20 open brackets 8 close brackets of the Environmental Planning and Assessment Act 1979, revoke their current delegation in relation to the conduct of appeals. 2. The WLPP, pursuant to section 2.20 open brackets 8 close brackets of the EPA Act, delegates to Council's General Manager the functions of the panel under section 8.15 open brackets 4 close brackets of the EPA Act with respect to the control and direction of appeals, subject to the WLPP operational guidelines. 3. That the amended WLPP operational guidelines provided in attachment 1 be adopted. The reasons are that the panel notes and agrees with the officer's recommendations, and the voting is unanimous. Item 6.3, development applications greater than 180 days reported to the WLPP. The panel's determination is that the Wingecarribee Local Planning Panel notes the development applications that are currently being assessed which have exceeded 180 days since lodgement. The panel recommends that procedures be put in place to ensure that any additional information required to determine development applications, that is, in a timely manner, be advised to the applicant in writing, and that an appropriate time limit be nominated for the information to be received. The panel recommends that a quarterly general performance monitoring report be presented to Council outlining the status of undetermined development applications in excess of 180 days. The reasons are that the panel notes and agrees with the officer's recommendations. The panel considers that it is necessary for procedures to be put in place to ensure the timely determination of development applications. The reasons are the panel notes and agrees with the officer's recommendations. The panel considers that it is necessary for procedures to be put in place to ensure, I think I might have just said that, beg your pardon for that repetition. The matter below has been drawn to the attention of the panel. The 9th of August 2024 Council meeting minute 2024/269 item 3. Quote, a routine reporting mechanism be developed for development applications which have been lodged for a period of 180 days or more, with short commentary, to the monthly meeting of the Wingecarribee Local Planning Panel until the ministerial order dated 1 July 2024 is satisfied. Such reporting to commence at the September meeting. The panel is of the view that consideration of development applications that would otherwise not come before it is beyond its remit, and that this is a matter for council operational management, and that the advice of the Director, Communities in Place and General Manager be sought. The final matter is 6.4, Land and Environment Court Matters, WLPP briefing. The panel's determination is that the panel notes this report and the memo provided under separate cover, outlining the status of all appeals relating to the determination or decision of the WLPP and deemed refusals which would, but for the appeal, have come before the panel for determination. Point 2, WLPP provide feedback on this proposed reporting mechanism for such appeals. The reasons are the panel notes and agrees with the officer's recommendations, and the voting is unanimous. There being no further items, I declare, well, first of all, I'd like to thank fellow panel members and council staff and speakers for their assistance today. And I declare the meeting of Wingecarribee Local Planning Panel of the 25th of September 2024 closed at 3:13 p.m. approximately.